The rule of law is a fundamental premise that underpins successful governance and a just constitutional system. One of the most difficult aspects of the Constitution is the idea of the Constitution itself. The Constitution, according to Aristotle, would not exist unless law reigns supreme. When the Constitution's term ends, it will not automatically expire. They exist to promote ideas and ideals as well as to accomplish some goals. The optimum approach to managing a community is through the rule of law. The rule of law is founded on the concept that the law, not the arbitrary whim of a few individuals, should determine society. As more emerging nations strive to construct a diverse and incomplete form of governance, the rule of law is becoming increasingly crucial. Malaysia is one of these countries. The rule of law is a well-known concept. For various people, this term has diverse connotations. The rule of law is a philosophical or political philosophy that outlines the essential prerequisites for the ruling or a method that permits those in power to rule according to the law. The law should be viewed as an autonomous authority, not as a subordinate of the political society. The rule of law is a vital indicator of how well people are protected by the law, and it is strongly associated with the democratically elected, responsible and responsive Western monarchies. As a result, the judiciary will be decoupled from the monarchy. The rule of law in a liberal democracy means that the law is regarded as good and that rule of law is an asset that may be displayed to the public. The article claims that legal theory is founded on legal philosophy and that rules are an important aspect of this way of thinking. The rule of law, according to Aristotle, was preferable to the interpretation of anyone on the law. In other words, Aristotle thought that a government's constitution was superior to human government. Law and order, according to Aristotle, take priority over chaos and disorder in every state and community. In this view, the government must be operated by the law rather than the arbitrary government's whims and desires. The use of the law as a deterrent to the use of unarmed force has a long history. In authoritarian regimes, even the plea for the government to maintain the rule of law is most plainly evident. The rule of law is both philosophical and political concept, and it's crucial to remember that it's also a practical doctrine. Joseph Ross and Alban van der Zee should be mentioned in the term of political philosophy. In the subject of political philosophy, these two theories are regarded as pioneers. According to Joseph Ross, the rule of law is a political concept that the legal system may or may not.
Public law is a theory of law governing the relationship between individuals and the states. Under public law, there is constitutional law, administrative law, and criminal law. As approved by the state, public bodies such as local government or government departments exercise specific rights to serve the public. The public law is the body of law that governs the exercise of such power by public authorities. According to history, Roman jurist Alpian is the first who argued the distinction between private law and public law. The evolution of public law began in Rome, and it has been divided into periods ranging from the formation of the Roman Empire through the establishment of the Justinian Empire. Constitution law is the first type of law that belongs under public law. Constitution law is a branch of law which deals with how government powers is distributed and exercised. But not all countries have codified constitutions, even though all states have a law of land, which can include a variety of mandatory and voluntary laws. One of the key tasks of constitution in this context is to indicate hierarchies and relationship of power. For example, in a unitary state, the constitution will vest ultimate authority in one central administration and legislature and judiciary, though there is often a delegation of power and authorities to local or municipal governments. The second category of public law is criminal law. Criminal law, also known as penal law, pertains to crime and punishment. Criminal law is the body of law that governs the arrest, charging, and trial of suspects, and also the penalties and treatment alternatives available to convicted criminals. Civil law must be distinct from criminal law. When someone steals, the criminal law is employed to regulate and manage the thief. Criminal law will be used to conduct investigation, make arrests, and make allegation. Stealing is a crime that is handled by criminal law since it is regarded as a crime against to the community. However, there is one problem that is very common in Malaysia, which is corruption. You must be wondering what is the relationship between law and corruption. Of course, it has relation because how the law is going to work is corruption has become big and bigger from time to time. Let me explain to you for more details. Besides the challenge to prevent and investigate criminals, there is also one cultural problem that thicken in society, especially for the rich people. The culture is they always covering up their criminal they commit with corruptions. Government servants are at high risk of corruption, especially for those involved in implementation of government decisions. The study found that 40% of the offenders detained by the Malaysian Anti-Corruption Commission were among civil servants from 2011 to 2015. Of course, it's a huge loss for the country. On 19 February 2018, in the Session Court here on Monday, a police sergeant was charged with soliciting and taking payment of 13,000 as an endorsement to settle narcotics case in 2018. Judge Murtazali Ahmad heard Muhammad Saifuddin, 31, plead not guilty to 3 charges. According to the first charge, the accused, who were sergeant in the Narcotic Criminal Investigation Division, bribed Abdul Rahman Mumtaz to close a narcotic investigation in Kepala Batas Alustar by requesting 30,000 ringgit from him. The impact of this corruption may have the impact on the government image and
So, international law is the body of rules that established by custom or treaty and also recognized by nations as binding in their relations with one another. It deals with principles and rules of conduct within a state bound to observe in its relations with other states all around the world. It is about the concern and the treatment of individuals within state boundaries. Domestic law of these states is applicable only within the states, but the international law is applicable on all of the states. They are subject to the application of the United Nations organizations, which is Persatuan Bangsa-Bangsa Bersatu and International Court of Justice. International law are the rules which aim at regulating the conduct of the states in their dealings with one another. A system of law implies that international law consists of a pattern of legal norms which are universally designed and which demand compliance from all members. These rules and principles are based on agreements, treaties, customs, and designed by nation states. International law has become crucial for maintaining international peace and security. International law is separated into two, which is public international law and private international law. Public international law is to administer the relationship between provinces and also international identities. This is a comprehensive system which is dealing with group rights, treatment of aliens, rights of refugees, international crime or problems, nationality problems, and also human rights. Public law is a theory of law governing the relationship between individuals, which is citizens, and also companies and the state. Under public law, there is constitutional law, administrative law, and also criminal law. As approved by the state public bodies, such as local governments or government departments, exercise specific rights to serve the public. The public law is the body of law that governs the exercise such power by public authorities. Among the issues that can be related to public law is a case between Malaysians that was detained in the Singapore Court of Appeal, rejecting the appeal of Malaysian citizen Agatron K. Dharmalingam regarding the death penalty he faced because he was caught bringing drugs to Singapore, which is known to be among the countries that with the strictest narcotic laws in the world. Nagatron, who is now 34, was arrested with heroin tied to his thigh from Malaysia to Singapore through the Woodlands Examination Centre. Private international law is a set of producer rules that determine which jurisdiction was applied to a given dispute. This is applied when the legal dispute has a foreign element in it. It is also used for privacy matters of citizens at the international level. The issue that we can discuss and related to this law is about how children can get their nationality based on their father and their mother, and this is applied to a Sikh mother who fight for this case for a declaration that Malaysian women who marry foreign spouses can automatically inherit their citizenship for their children born abroad. The lawsuit was initiated after the government refused to allow their children to qualify for citizenship. According to Home Minister Hamzah Zainuddin, the provision in Malaysia's Supreme Law that only enable father of Malaysian nationals to grant automatic citizenship to their children born overseas is not discriminatory.
Private law refers to any situation that involves relationships between individuals. Common law is another term for this. This includes property law, family law, contract law, and the last one is tort law. An organization and its employees are a general example of where private law can be found. In the same way that the employer sets the rules of conduct at work. Furthermore, this can be seen in our daily rules, which prohibit smoking in prohibited areas. The authorities can impose a compound of 250 ringgit, and if they fail to pay the compound, they will be charged in court either fine not more than 10,000 ringgit or imprisoned for not more than 2 years. There are 4 types of law. First and foremost is contract law. It refers to an agreement entered by 2 or more parties based on their mutual rights and obligations that must be settled by them. There are 3 aspects to concluding a contract law, such as buying real estate, applying for a car loan, signing employment-related paperwork, and the employees finally having agreed to the terms and conditions imposed before purchasing a product or service, such as damage or the determinations of the contract. Because all agreements must be respected, contract law has been established as a mandatory principle to be followed. The second type of law is property law. Property law is also known as real estate law, which deals with transactions related to residential property and personal property. Ownership of property can be exchanged through contract law, and if the property is exchanged not in accordance with established law, individuals can claim under tort law to protect it. Property law is divided into 2 types, which are personal property and commercial property. Personal law involves all aspects of the law, whether to buy or sell personal property. For example, a sale and purchase agreement (SPA) is a document that contains real estate transactions, terms and conditions. Commercial property is a land that has been transformed into a profit-making business by the ownerships. For example, Mr. Ahmad operates his own business by renting out services like rental properties to Mr. Ali in exchange for profit. The third type is tort law. Tort law is a body of law that protects people from the irresponsible actions of others. This law is aims to ensure that victims are rewarded for any consequences created as a result to prevent them from repeating the offense again. There are three categories in tort law, which are intentional torts, strict responsibility torts, and the last one is unintentional torts. The situations that shows under the unintentional torts is slipping and falling negligence. The last one is family law. Family law is a branch of law that deals with issues such as divorce, adoption, and parental rights. This law handles situations involving family, courts, procedures, and others' responsibility.
The importance of the rule of law in the governance process is evident from the preceding discussion, particularly in the context of having responsibility and accountability. Humans have a written constitution in Malaysia that establishes a clear set of guidelines for the allocation of power among the various executive entities and how they function. Thus, in Malaysia, the supremacy of the constitution, which enables and prescribes those who act on behalf of the state, is referred to as the rule of law. It is crucial to highlight, however, that having a written constitution based on the principle of constitutional supremacy does not ensure that the rule of law will be respected and recognized in a given legal system.